not be morning, but welcome to the Legacy Years. So, this is a podcast where we talk about embracing the joys and challenges of aging. And my goal is to share valuable tips and information that will help folks do just that. And with that in mind, today I welcome Marcie Johnson. Welcome, Marcie.
Thank you, Christy. I appreciate you having me on
Yes,
today.
and I appreciate the information that you're going to share with us. I think this is an interesting topic. A lot of people, everybody knows about this topic. We're going to talk today about trusts, but I think people don't really understand it and don't know if it's something that is for them or if it's something that they should do. So I hope that they'll come away with listening to us for the 20 or 25 minutes that we talk about this and know a little bit more about trust and understand if it's something that they may want for their family. So thank you for being here.
Sure.
So let's just kind of dive right in. I want to talk first about, just in its basic sense, what is a trust?
So, a trust is it's a concept. And that's what makes it kind of hard for people to understand because you can't touch it. You can't feel it. It's it's a concept. And the best description that I have come up with on how to describe a trust and is a bucket.
Okay.
And so, and for right now, I'm going to use the example of a living trust. Sometimes they're called a revocable trust. And this type of trust, so think of it like a bucket.
Okay.
And it's got a handle on it, on the top. So think of like a water bucket. Now, if you're married, it'll have two handles. But whoever is in charge of the bucket holds that handle. And you've got to fill the bucket. So you put things in this bucket that you want to be managed by the holder. So let's just say you put a bank account. Let's just start simple. So you put a bank account in this trust and you have instructions on how you want what's in that bucket to be managed. So any type of property or money or things, household things, specialty items you want to be managed by special instructions, you put them in the bucket.
Can you put anything in there?
You can put anything in there. There are some things that you may not want to put in there. So, and we can talk about that in a minute. But as long as the person who created the bucket, so there's several roles. There's what's called, I call them a trust maker. That's the person who creates the bucket, creates the trust. And then the second role is a trustee. That's who manages the trust, who holds the bucket and manages what's in it. And then you have beneficiaries. That's who gets what's inside the bucket or the trust at a certain time. Something has to trigger an event in order for what's in the trust, what's in the bucket, to go to named beneficiaries. But the benefit of this bucket is if you can't hold the bucket anymore, then you've named people to hold it for you. And you don't have to go through necessarily a court process in order to get someone named to manage it. They just automatically come on board because of your instructions.
Okay.
That's in a nutshell. It's a set of instructions regarding a certain asset or multiple assets in which you want your rules followed. And that's what a trust is. And it's not touchable, it's not tangible, but a bucket I have found is a good analogy.
I feel like that's a great analogy because everybody can picture that.
Well, a good friend of mine, a coach, shared with me that illustration, and I have used it ever since, and it seems to work well.
So when you think about creating a trust, are there certain families who might not want a trust, or would it be something that anybody would want?
Well, anyone can benefit from a trust, but it may not be the right tool for everybody. So, like all estate planning tools, a trust is just one tool in the big toolbox. So, it may be right for some and may not be right for others. It really just depends on what you're trying to
Okay.
accomplish. I, I have clients that come to me and they say, I want a trust. And that may be true, but it's kind of like telling your doctor, I want surgery. And like, okay, well, what are we trying? What are our goals? What is it that we're trying to fix? Because there's multiple surgeries that we can have. Same with trust. There's multiple trusts that we could do, and they've all got different goals and different scenarios, and they're tailored specifically to you. So when someone comes and says, I want a trust, I say, okay, what kind of surgery do we need to perform? And, so it's similar in that respect. But I would say if you don't have any assets, and let me describe, when I say property and I say assets, I'm not talking, I'm talking about money. I'm talking about bank accounts, life insurance, your house, just all your stuff. Not limited to just real estate or just, stocks and bonds. I mean, so all your stuff. If you have, and there's no dollar number on it really, but if you have some assets that you want to go to somebody, it's really going to depend on what you're trying to accomplish. But if we're talking about $10,000 or $15,000, probably you're not going to want to do a trust just because of the cost to set it up. There may be other ways that we can make sure it goes to the people you want it to go to without the administrative burden of setting up a trust.
So when you think about the difference between a will, which kind of does what you've said, like, oh, this is what I want done with my house. This is what I want done with my, assets. This is what I want grandma's china. This is where I want grandma's china to go. When you think about the difference between those two, because they basically do the same, same instructions. What's the biggest difference?
Well, so the way I describe it to my clients is the difference between a will plan and a trust plan is a will plan is a court-controlled plan. And what that means is that you've got a will, and a lot of people don't realize that a will is not a will until the judge says it is. So you have this document that says last will and testament. It has to meet certain requirements, and it has to be signed in a particular way, and that all has to be proven through the court system. So if you have a will and you plan to use that will, you have to take it through court. And so it's a court process, which means the court oversees that process. And your timetable for getting the will administered is based on the court's timetable because you've got to schedule a hearing. I'll tell you right now, Dallas County, even Collin County, it could easily be 3 or 4 months, maybe longer, before you get a hearing. So you're just at the mercy of the court. There's filing fees that are associated with filing that will, and it's public. So when you go through a probate process, you have to tell the courts what assets are going through probate. And a lot of people don't want the public knowing what assets they have. And if you have a case number, you can look up anyone's will and estate plan that's been filed in Dallas County or whichever county that you're looking at. So there's privacy concerns. The court's timetable, it's governed by the court. And it can be expensive. A lot of people don't realize is, a will plan itself may not cost that much, but to take it through the probate process, at least here in Texas, right now, you really need an attorney to take you through that process. And so there's attorney's fees on the back end.
Yeah. Interesting. I never thought about the privacy issue of a probate versus a trust, but That
Sure.
is an interesting one because we look up things in the court records all the time, being in the real estate industry. So there is a lot of
Yeah.
information out there people don't realize.
Yeah. Now, there could be a reason why you would want to go through probate. If you have a lot of creditors, um, there's a process in which you can cut off creditors' claims if you go through the probate process. So a lot of times, if people with a lot of creditors, it may make sense to go through that probate
Interesting.
process. But as compared to a trust plan, so a trust plan, we call it a family controlled plan. So as compared to a will plan, if you have a trust plan, the idea is, I know we'll talk about this later, is if everything that you want to be in the trust is in the trust, then usually you can avoid the probate process altogether. So instead of filing this document, it stays with the family. It's not filed anywhere. It's a contract, but it's not filed anywhere. And so when mom or dad, let's say they created the trust, when they pass away, the kids just call the attorney that set up the plan, say, tragedy has happened, mom and dad are gone. And the attorney says, okay, can you come in next Tuesday? And you can get in quickly and then you can start the administration. So it's private. It's you can avoid a lot of those after death probate fees, filing fees, and administrative costs. And now it costs more usually to set up front, but it can be less expensive on the back end because you're avoiding that process.
Well, and I also think I mean, death is not easy as it is. And if you have someone that's holding your hand through this process already because you've got this document created, it just makes it a little bit easier.
Sure.
Yeah.
I mean, I do a lot of probate. I've never had a client say that was fun. Let's do it again. But and people don't realize, or there's a misconception, you still have to do some of the same things that you do in probate when you have a trust. It's just not overseen by the court.
And I think that's an important distinction because I've been through probate and I got served because my attorney did something wrong. And so it was a whole, drama. I was like, why is there a police officer at my door? Your heart starts beating.
That would be scary.
Yeah.
I understand.
They were so nice. They were like, it's just a formality. I was like, okay, thanks. But yeah, it wasn't fun. So, I do want to get to talking about funding a trust, but I also want to talk about, because you said we're talking about a living trust, a revocable trust. There is also something called an irrevocable trust. And what's the difference between those two? And why would someone want to do something that was irrevocable?
Sure. Well, like I said, the imagination is the limit as to how you can create a trust. But your standard, if I had to categorize it broadly, you've got revocable trusts and irrevocable trusts, like you said. So you're going to use a revocable trust for your traditional estate planning needs. I've got these assets. I want it to go to these people upon my death, and avoiding that court process. An irrevocable trust, the irrevocable meaning there's something about it you can't change. It doesn't mean that all of it can't be changed, but there's something about it you can't change. We use irrevocable trusts when you're trying to make gifts during life. If you want to gift a certain amount of money to an irrevocable trust for the benefit of, say, a son or a daughter that you want them to be able to have access to the gift, but not be able to maybe manage it themselves. So there's more restrictions on an irrevocable trust. I will tell you, I use irrevocable trust a lot in elder law planning.
Okay.
So for people who are wanting to qualify for some sort of governmental benefits to help pay for long-term care, like Medicaid, or for veterans, if they're looking to get veterans benefits. For a lot of those programs, there are limits onto the amount of assets you can have.
Right.
So we use irrevocable trust to get money out of our estate. So we gift it away. Now, you can gift it straight to the individuals you want to safeguard it for you. But the danger in that is that they could lose it. They don't mean to lose it, but they have a judgment against them. They're sued. They go through divorce, and the money that's earmarked for, let's say, mom and dad gets lost. So we can take assets and move it to an irrevocable trust that's managed, say, by children, but the kids don't own it. So if something bad's going on in their life, the money that's earmarked in this trust can't be lost, but it's also taken out of mom and dad's estate so that if they want to qualify for governmental benefits, once a look back period has passed, then they can legitimately tell these governmental agencies, I only had X amount of dollars. I gifted, this much to an irrevocable trust, but that time limit for which you to look and see that gift has passed. So that's out of my estate. Now I can qualify for some governmental benefits.
Got it. So you might have a trust and an irrevocable trust. Someone could have both. And the irrevocable trust only has certain assets in it, and the trust may have the rest of your assets in it. Okay.
Right. We also do irrevocable trusts for beneficiaries. So even if you have a living trust, a lot of times what my clients want to do is make sure when they give it to their kids that the kids don't lose the inheritance. So what they do is they set up a trust for the kids. So instead of, under, let's say, a will, each child gets $100,000 outright. Well, instead of giving it to him outright, we give it to him in trust. That trust is irrevocable. But we do that as a benefit to the child, because if the child, they can still be in charge of it, but if they go through a divorce, have credit problems, bankruptcy issues, the trust doesn't force them to make a distribution to pay those creditors. So in almost all of our living trusts, an irrevocable trust is established when the trust makers die, because it's a benefit to make sure the kids get to keep what they got.
Got it. And an irrevocable trust is that it can never change. You said there's certain aspects of it that can't change, but there's certain aspects that can.
Yeah, it depends on how the trust is written. A lot of times, let's say for a beneficiary trust, it's an irrevocable trust. The kids can't change necessarily who receives it if they don't spend it all. So if kid dies, the parents say, well, it goes to my grandchildren, or it goes to my other child. The child can't change who the beneficiary is to whoever they want it to be. Now, they can take the money out of the trust, but then they lose the asset protection. So there's the asset protection is because there's something about it you can't change. Now, we also have what's called I don't want to get too technical. I've got a trust protector. A lot of people have heard of a trust protector. Because these trusts are irrevocable, if the law changes, we as attorneys need a way to get back into the trust to make the change to keep the trust effective. And so a lot of times we have what's called a trust protector, which is an outside third party to come in and make the change. Yeah. So usually, even if you have an irrevocable trust, like I said, there's at least one thing you can't change. But if a trust is drafted well, sometimes there are workarounds in order, for contingency. We don't know what's going to happen in the future. Right. Can address those concerns based on the language that's in the trust through outside means.
And I think that's an important thing that you stated, if the trust is drafted well. And so I caution people, always use someone that always use someone that was recommended, and be sure you do
Mhm.
your homework on, is this person really an estate planning attorney, or are they a general attorney and they're trying to do something that maybe they don't do every day? So that's just my little
Absolutely.
PSA that I'm going to pop in there. So let's talk a second about funding the trust, because you can create a trust and put nothing in it.
That is true. Yes. And as we were talking before the podcast, some people choose that strategy when having a trust. To get the full benefit of a trust, the idea is you've got to put the assets into it. And how do we do that? So if you have, let's talk about a revocable trust. So normally what you're doing with a revocable living trust is you're putting all the assets into it that would normally go through probate. You're putting it into this trust, because a trust it doesn't have a life expectancy per se. So it it the trust doesn't die.
Yeah.
So the assets are already where they need to be. There's a triggering mechanism saying, okay, mom and dad are gone. Now it goes to kids, but we don't have to go to the court in order to get permission in order for the assets to go where they need to go. We've already got instructions. So if we're going to put, let's say, our house in the trust, we do a deed from your name into the name of the trust. Nothing changes. Your homestead rights don't change. Your over 65 exemptions don't change. It's just now that the name on the deed is now a trust. Your bank accounts, your brokerage accounts, you still have full access on those accounts. You can put stuff into the trust. You can take stuff out of the trust. But instead of being in your individual name, it's in the John Doe Living Trust. And the idea is to get all those assets that would normally go through probate into the trust. So when you do pass away, we don't have to go through probate.
Mhm.
Now, there are circumstances in which we don't get everything in there. So a good estate plan will always have what's called a pour over will.
Okay.
Now, that is a that is not,
Sounds like
it's not necessarily a legal term, but it's what estate planning attorneys call it. So it's a will that says if I left anything out of my trust, it all goes into my trust. So you'd have to probate that one item. You would have to go through probate, but it would get everything into the trust.
got it.
Now I do have clients that don't want to mess with funding while they are alive, and that's okay. But it just means that you are going to have to go through probate upon death.
So,
And you,
uh,
oh, go ahead.
why would, is that just a personal preference on someone's part, or okay?
Or, well, you can set up a trust in a will, but I don't do that because you're forced to go through probate. And that's one of the whole reasons why you're doing a living trust in the first place. But a lot of times clients don't want to do it. But I have done several emergency room trusts in which they passed
Yeah.
away before the assets were able to get in there. And it was okay because at least they had their instructions in place. So now we're going through probate, but everything's going to follow the way mom and dad wanted
Yeah.
it. And so it may not be ideal, but it's better than the alternative of not having a plan at all, or having an outdated estate plan in which it doesn't represent your wishes
Yeah.
anymore.
Yeah. So talking about, all the different avenues, because there are so many, I feel like it's very specific to each individual. And if somebody was interested in learning more about just their personal situation, Marcie, how could they reach out to you?
Oh, thank you. Well, yeah, I would love to. My firm is called the Johnson Firm, and what distinguishes us from others is that we're a family owned firm. I a long time ago partnered with my dad, and so we're a father-daughter team. But our motto is our family helping yours. So I just want to be able to help as many people who have questions. I don't want them to feel intimidated by going to an attorney. And so really, we just talk about options. So I can give you my our phone number at the office is so the name of my firm is the Johnson Firm, and we're located in Richardson off of 75 in Richardson. And our phone number is 972-497-1010. You can also look me up on the web. My website is www.johnsonfirm. It's my last name, JOHNSON, firm.com. And, if anyone wants to talk to us about just options, we'll be glad to talk to them. And if they will mention that they heard me on this podcast, Christy, as a benefit to you, I will waive my initial consultation.
That's amazing.
To talk to them, because I just want people to get the help that they need. And, whether they decide to go with me or not, I just want to make sure that they know what their options are. We're big on education.
Yeah.
So because there are so many trusts out there and there's so many different scenarios and what you're trying to accomplish, it's what's right for your family. And that's what we just want to talk about.
That's great. And I think that that's important. And that's why we are friends, because that's what I want. I want people to work with people who really just want the best for them and have their best interests at heart. So I appreciate you doing that. That's an amazing offer. You guys take her up on that if you want to. And thank you again for being here with me today and for all the information that you provided. It was a lot, and we appreciate your knowledge and expertise.
Well, I totally appreciate